This is an exact textual analysis of an office with two hats, and the legal line dividing them. This is not about whether a surrogate's office schedules hearings, stamps orders, or maintains case files. The rules require all of that. The question is narrower. When a matter of law arises in a superior court case, who actually possesses the authority to answer it? This is about jurisdictional accuracy, recognizing exactly where administrative duty ends and judicial authority begins. Segment 1. To understand the office, we have to look at the governing statute that creates the first of its two hats. This document outlines New Jersey Statute 2B 14-1. It states, quote, "The surrogate shall be both the judge and clerk of the surrogate's court." That grant of dual authority is entirely real and legally valid. But look at the text carefully. The grant is strictly court-specific. In the surrogate's own court, handling uncontested probates and basic qualifications, the surrogate legitimately adjudicates. This film is not about the surrogate's court. We are examining a different venue entirely, the Superior Court, Chancery Division, Probate part, where contested estates and guardianships are heard by a judge. This is the venue for docket S-8455. While the first hat grants judicial power, that power is trapped entirely within the boundaries of a single specific court. It does not carry over. Segment 2. When we move into the Superior Court, the office's status changes. Court Rule 134-2-A strips the judicial title and applies a new one in this venue. It reads, quote, "The surrogate of the county shall be the deputy clerk of the Superior Court, Chancery Division, Probate part, a clerk," and the rule's second sentence fixes exactly where staff loyalty runs in that capacity. It mandates that all employees serving as deputy clerks are responsible to the clerk of the Superior Court, overriding the county that hires and pays them. In the Superior Court, the surrogate and staff wear the second hat. They possess zero judicial power and function exclusively as administrative subordinates to the court. Segment 3. The deputy clerk's administrative powers are strictly enumerated. Rule 4.83-1 provides that enumeration. The rule grants the deputy clerk exactly two acts. They may, quote, "fix the return date of the order to show cause and execute the same." But attached directly to that grant is a specific boundary condition that terminates this administrative authority. The rule explicitly defines its own stopping point. The boundary between clerk and judge is textual, not theoretical. The authority ends, quote, "unless the procedure in a particular case raises doubt or difficulty." Read that last clause again to understand its operational weight. This stopping point is entirely self-operating. The rule does not require a formal objection from a party for the limit to trigger. The condition objectively exists, or it does not. The deputy clerk's authority is highly fragile by design. The moment any complexity arises, it collapses, and the matter defers to a judge. Segment 4. The underlying state statute is built with the exact same architecture as the court rules. Chapter 2B14 names each office that may exercise powers. For the only office an ordinary employee can hold, the special probate clerk, it defines exact parameters. This operates in law as a closed list. If a power is not enumerated here, it does not exist. The statute names exactly 4 powers: taking depositions of witnesses to wills, qualifications of executors and administrators, acceptance of trusteeships and guardianships, and oaths. 4. The statute leaves no room for interpretation. The administrative ceiling is hard-coded at these 4 specific acts. Now look at what is explicitly absent from this statutory list. Fixing a fiduciary bond does not appear anywhere on this list. Deciding whether a court-ordered accounting duty exists does not appear on the list. Adjudicating the sufficiency of a tendered pleading is not on the list, for anyone in the office, including the surrogate. These are questions of law. They are strictly judicial questions. Keep the dual nature of this office in view, because everything that follows in this series occurs in the Superior Court, under the second hat, where they operate strictly as administrative clerks. The rules draw the line. The record shows what crossed it. This is Act 2 of 8 of Received Not Filed, the Union County Surrogate's Office, and the Questions Reserved for Judges. The Determinations. Segment 1. On June 7, 2023, the court signed a judgment appointing a temporary guardian. This shows paragraph 2D of the judgment. It directs the guardian to enter a surety bond, but the required dollar amount is left entirely blank. The text presents two exclusive paths: fix an amount or waive it for extraordinary reasons. Neither is filled in. The judgment cites the authorities for this requirement directly on its face: Statute 3B:15-7 and Rule 1:13-3. The order explicitly states that the court shall approve the bond as to form and sufficiency, not a clerk and not an administrative office. A signed order offering two exclusive choices, with both left blank, creates a procedural vacuum. It is a reality completely in doubt, a fundamental question that only a judge has the legal authority to answer. Segment 2. The very next day, June 8, 2023, the surrogate's counsel, Lisa Taylor Brophy, sent an email. At 12:49 in the afternoon, she wrote to the lawyers on the case asking if counsel wanted the temporary guardian to be bonded. She noted that he was not previously, quote, bonded by the court. Note the exact phrasing there. Faced with a blank line on a court order regarding an amount fixed by statute, the legally available path for a deputy clerk was to refer the document back to the judge. Instead of seeking the court's instruction, the office put the question of a fiduciary bond to a vote, canvassing the litigants to establish the rules of the case. Segment 3. We return to page 4 of that same June 7th judgment. Looking at this section, paragraph 9 explicitly checks the box directing the named guardian to file an annual report of well-being. The waiver line below it is blank. Further down, paragraph 10 checks exactly one accounting tier, a comprehensive accounting, presumed for estates between $1 and $5 million. Just like the previous section, the periodic accounting waiver line remains completely empty. The order is active and the duty is live. 7 months later, on January 22, 2024, the surrogate's counsel stated in writing that a temporary guardian is, quote, not usually required to file an accounting. The phrasing is hedged with the word usually. We should be clear. This analysis does not claim anyone relied on that sentence, and it accuses no one of a crime. But whether a fiduciary owes an accounting to the court is strictly a question of law. Against a signed judgment imposing that exact duty, the office's counsel made a contrary legal determination. Segment 4. On July 24, 2025, the timeline shifts again. The office noted in written correspondence that a previously filed instrument had been, quote, discarded. State statute structures the recording of court orders as a one-way street. The office has a duty to record the court's actions, but the law confers no administrative power to unrecord them. There is a perfectly innocent reading here. It is entirely possible a stamp was applied in error and simply needed correcting. However, once an instrument bears the stamp of the court, deciding whether it holds legal effect becomes an adjudicative question. The issue at hand is not the mistake itself, but the venue chosen to resolve it. The office decided the status of a court record privately, in correspondence, rather than bringing the question before a judge on the official record. 3 separate dates, 3 distinct written answers provided by administrative staff to resolve ambiguities. Measured. Those were answers. The rules call them something else. Segment 4. On July 24, 2025, the timeline shifts again. The office noted in written correspondence that a previously filed instrument had been, quote, discarded. State statute structures the recording of court orders as a one-way street. The office has a duty to record the court's actions, but the law confers no administrative power to unrecord them. There is a perfectly innocent reading here. It is entirely possible a stamp was applied in error and simply needed correcting. However, once an instrument bears the stamp of the court, deciding whether it holds legal effect becomes an adjudicative question. The issue at hand is not the mistake itself, but the venue chosen to resolve it. The office decided the status of a court record privately, in correspondence, rather than bringing the question before a judge on the official record. 3 separate dates, 3 distinct written answers provided by administrative staff to resolve ambiguities. Measured. Those were answers. The rules call them something else. Before the 14 days, there was a judgment and a revision round. We called this interlude the version among counsel. Segment 1, the circulation. On December 18, 2023, Christopher Weldon circulated a proposed judgment discharging outgoing guardian Donald Vanarelli to 13 addresses. Vanarelli then asked for 3 revisions, including that Amanda Wolfe be formally discharged. The next day, December 19th, the surrogate's counsel, Lisa Taylor Brophy, officially set the course. She directed that an updated version should be prepared by Mr. Weldon with the discussed issues addressed. An official, documented channel for revisions was now open, and the responsibility for drafting those specific changes was exclusively delegated to the Public Guardian's Council. Segment 2. The Family's Revision. The ward's daughter specifically asked for accounting language, a requirement that the outgoing guardian provide an accounting of the funds before his discharge. This request was known and acknowledged in writing. Amanda Wolfe, the ward's own counsel, explicitly confirmed it on January 22nd, stating, Mr. Vanarelli acknowledged the need to add the accounting language. Mr. Vanarelli himself later documented the request on the record, writing that someone asked for the inclusion of an accounting requirement, and adding, I don't know why that language was not included. The legal professionals involved all clearly understood and discussed the family's requested revision, yet that agreed-upon language did not make it into the final text. The family's revision was mutually acknowledged and universally documented by the parties. Its subsequent disappearance is a matter of record, not a misunderstanding. Segment 3. The version that mattered. On January 2, 2024, Mr. Weldon sent out the revised judgment, noting changes in the preamble and on pages 14 and 15, but the distribution list had changed. The operative text was sent to only 2 recipients, Mr. Vanarelli and Ms. Wolfe. The family litigants, who had been on the email thread when the draft circulated in December, were entirely excluded from the message carrying the final text. January 3rd, Vanarelli wrote, "Please have the judge sign it ASAP." The court signed it that day. At 3:55, Brophy transmitted the judgment, instructing, "Here is the signed judgment. Please forward the judgment on to the rest of the family as well." By narrowing the distribution list, the family was locked out of reviewing the final text. They received the judgment after the fact, carrying the binding weight of a judge's signature. Segment 4. What the signed instrument actually held. Every revision requested by counsel was successfully implemented, including the discharge of the ward's own lawyer, leaving no court-appointed advocate to press the issue. In contrast, the accounting language requested by the family was never included. The only accounting clause that did survive the revision round was downgraded to a strictly informal process. More importantly, the text contained a specific conditional loophole. The informal accounting was required only if requested by the OPG, the exact same office whose counsel drafted the instrument. That request by the public guardian was never made. The facts show knowledge and non-disclosure. The words were chosen carefully. The language was never included, not removed. The court simply signed with the narrow distribution group put before it. The mechanics of drafting and distribution prioritized the legal professionals' protections, while entirely stripping the family of their agreed-upon oversight. Every implemented revision was counsel's. The family's revision was never in it. This tactical omission forced the family into a new battle, requiring them to object in writing to paper the issue back into the record. As this title card establishes, we are looking at a precise chronological window, a 14-day interlude between January 22nd and February 5th, 2024. This slide outlines Segment 1, starting January 3rd. The discharge judgment ended the former guardian's service, but named only the incoming public guardian. The court required no accounting, leaving the outgoing guardian with no formal duty to provide a record. That explicit omission became the foundational conflict, triggering a series of written objections from the family. By January 22nd, surrogate's counsel Lisa Taylor Brophy replied in writing. She stated that a temporary guardian is, quote, not usually required to file an accounting. The family continued pressing their demand. Following this, 14 days pass without a single docket entry. This 2-week stretch of bureaucratic stagnation serves as the baseline for the sudden, same-day reversal of February 5th. Segment 2 moves the timeline to the morning of February 5th. At 9:05 a.m., the relator emailed the office, laying out the judgment's revision history, the missing accounting language, and the procedural clock already running. In Exhibit 1, Lisa Brophy replies at 10:09 a.m., over her invariant signature block. She acknowledges the omission. There should have been a requirement for an accounting. She provides a written commitment. I will prepare an order. I will send out the order today. The surrogate's counsel is personally promising the immediate creation and distribution of a judicial instrument. Segment 3 shifts to the events of that exact same afternoon. The filed order of amending judgment asserts it is by the court. Its recital matches the morning diagnosis, the court not having required the former guardian to provide an informal accounting. It mandates an accounting by March 1st, assigning the deputy clerk to handle service. The instrument carries the signature of the presiding judge, while the office's own scan metadata shows the file was processed at 3:14 p.m. that afternoon. This sequence shows the system can move with remarkable speed, delivering a signed, filed order mere hours after a private email commitment. Segment 4 outlines the innocent reading of this timeline. Under this theory, the omission was flagged, chambers agreed with the assessment, and the court signed the correction the very same day. Courts are capable of acting quickly, and this amending order ultimately gave the family exactly what they had requested. While the result is practically sound, accepting this reading requires looking past a silence in the procedural chain of custody. The visible record shows a commitment to prepare the order, an afternoon filing, matching language, and service routed through the deputy clerk. What the record does not show is the middle, the formal submission trail and the docket entry linking the email to the judge's desk. This analysis is based strictly on logic and law. It asserts nothing beyond the documents shown and accuses no one of a crime. 14 days of inaction, followed by a single morning email and a same-day order. When the middle steps are missing from the public record, it raises the question of who actually prepares and who actually enters the orders of the court. Act 3 of 8. This will be the date. The documents shown in this sequence are filed, served, or received instruments and correspondence from docket S8455 and related public records. Quotes are verbatim from the documents shown on screen, with author and date. This is an analysis of logic and law. It accuses no one of a crime. The court system draws a strict boundary between two functions. Processing paperwork and managing a calendar is administrative. Advising a litigant on how to maneuver through their case is substantive legal steering. This analysis focuses on the Union County Surrogate's office. Specifically, we are looking at the actions performed by an individual who consistently signs their correspondence under the title of Counsel. To see where the boundary is drawn in practice, we have to look past what the office claims its role is and examine the exact written record of what it actually does. Segment 1. The date. In November 2023, in an email thread titled Date Change for Hearing, the Surrogate's Counsel managed the calendar for a Superior Court proceeding. After tracking the judge's trial and vacation schedule, the author writes, I just heard back from the judge, and he does have availability on Monday, November 6, 2023 at 1:30 p.m. This will be the date of the phone conference/oral argument on this matter. Fixing the date of a proceeding is a standard enumerated administrative act for a deputy clerk under Rule 483(1). But look at the bottom of the slide. Every email in this set closes with the exact same signature block. Lisa Taylor Brophy, Esquire, Counsel, Union County Surrogate. This establishes our baseline. The office uses an authoritative legal title, Counsel, to sign off on a purely clerical procedure. Hold on to that pairing. Segment 2. The advice. By April 2024, the correspondence shifts to an unrepresented member of a ward's family. Writing to that family member, Miss Brophy construes a guardianship judgment. Paragraph 5 of the judgment indicates that OPG cannot transfer, sell, etc. the real property without further order of the court. They do not have authority to sell it until they file these motion papers and get court approval. 3 days later, she follows up. Feel free to reach out to OPG to let them know that they do not have authority to sell the property without seeking an order from the court. Construing a court judgment and opining on a fiduciary's authority is not a procedural answer. It is a substantive legal conclusion, and in this instance, the legal conclusion explicitly favored the unrepresented party who asked for it. Both of these facts matter. The move from scheduling dates to interpreting law and the favoring of a requester show an active role being played. Segment 3. The steering. On March 20, 2025, Ms. Brophy wrote to an estate's pro se administratrix, with the opposing party's lawyers copied on the thread. The letter outlines a specific legal maneuver. Prior to the court entering the order dismissing the complaint, you can withdraw your answer and the court can grant the relief in the verified complaint and discharge Mr. Vanarelli. Looking directly at the raw document, the path to securing relief is clearly mapped out for the litigant. followed once again by the Counsel signature block. Yet, later in that exact same communication, the author writes, "The information I previously provided was not advice. I was simply stating procedural facts." The first page of the raw document confirms this self-assessment, an explicit, written denial of providing legal advice. The office is detailing a precise tactical maneuver, advising a party to withdraw an answer to secure a specific court order, while simultaneously insisting in writing that they are only stating procedural facts. Holding those two statements side by side shows exactly how the office masks substantive legal steering as mere administration. Segment 4. The concessions. Scheduling by a surrogate's office is completely lawful. Rule 483-1 expressly authorizes it. Statutory officers like Special Deputy Surrogate Susan DiNardo operate exactly as contemplated, and in every one of the 8 messages reviewed, the pattern holds. The observation that survives is exact. The individual performing the deputy clerk's acts, construing judgments, and framing options, signs as counsel, and in every message, the title never changes. This is a documented practice where an authoritative title is used to push past statutory boundaries. The evidence sits on the page. The correspondence shows the practice. The counter shows its force. This chapter is an interlude. It concerns the months before any argument reached the counter, when the primary dispute was over the file itself. S-8455 is a study in authority. It focuses on the preliminary question of basic public access to the record. Access to the file is a requirement for building a case. This administrative question acts as a gate before any actual litigation can begin. In a system built on documentation, management of the record functions as management of the facts available for review. Segment 1. Standard records architecture for the probate part and the surrogate's court starts with a request to the county surrogate. The rules route these requests through the office. A denial travels up to the administrative director and finally to the appellate division. This structure governs every standard inquiry and applies to every citizen. In this specific matter, the office deciding what could be seen was the same office whose own conduct was the subject of the requests. The system places the entity that manages the record in the position of gatekeeper, creating a closed loop of administrative authority. Segment 2. In the spring of 2025, the family served record subpoenas to obtain the contents of the file. The family used standard discovery mechanisms, which were met with immediate legal motions from both the county and the state. On June 24, 2025, the court addressed those motions. The surrogate's own motion to quash was granted in part, while the public guardian's motion was granted in full. The order also specified that service was, quote, deemed served upon uploading to e-courts. These rulings demonstrate how the initial attempt to access the file met immediate opposition from the offices responsible for guarding it. Segment 3. On August 8, 2025, the office sent an email response to ongoing correspondence, signed only Union County Surrogate Court, with no individual name. It stated communications must take the form of formal pleadings, and records require an availability determination and statutory fees. Weeks later, a separate OPRA request to the county drew no response, and County Counsel Moshood Muftau directed the requester to stop contacting employees. These procedural requirements create a series of administrative hurdles that can exhaust an inquiry before it ever reaches a courtroom. Segment 4. On September 30th, the family fulfilled every requirement of the August email, tendering a formal pleading with a fee enclosed and service on all parties. The document was returned marked received, but it was never actually filed into the record. One level up, the administrative office of the courts issued its own denial letter on September 9th. By January 2026, the AOC itself had moved to quash the records request. This circular path through the bureaucracy often leads a requester back to the same starting point, regardless of where they appeal. There is an innocent reading of these events. Fee schedules, availability reviews, and orderly correspondence are standard custodial administration. This analysis asserts no individual motive and accuses no one of a crime. What the record maps is a structural reality. At every door to the file, The office that kept it, or the office above it, sat as the gatekeeper, the movant, or both. The keeper of the file decided what the file would show. The next act is what happened when a formal pleading reached the counter. Access to a courtroom begins at the filing window. It is the entry point for every legal action, governed by a set of procedural rules designed to be automatic and impartial. If the entry point is blocked, the case stops before it can even begin. In the fall of 2025, a specific legal package was hand-delivered to a New Jersey courthouse. The clerk's office physically accepted the documents, but the filing stamp never touched the paper. This administrative anomaly took place inside the Union County Surrogate's office, within the records of docket S8455. When a document is caught in this limbo, it creates a silent blockade. The official court record remains incomplete at the counter, stopping a judge from ever seeing the paperwork or intervening. Segment 1. The delivery record. On September 30th, 2025, at 1:38 p.m., a signed motion package was emailed directly to the surrogate's office. The next afternoon, October 1st, at 4:07 p.m., a professional process server tendered that same package in person at the front counter. The delivery included a proposed form of order, a notice of motion, a certification, a brief, and exhibits. This sworn affidavit of service records that the package was accepted by Deputy Surrogate Kelly Coyle, acting as the person authorized to accept service. And the sworn affidavit records one final detail on the bottom line. Quote, check included for filing fee, $25. Delivery, acceptance, and the tender of the required fee. Every step of the physical transaction is documented, dated, and sworn under oath. Segment 2, the October 2 letter. The very next day, the office issued a response on official surrogate letterhead. The text states, quote, upon review of the notice of motion served, it is determined the documents submitted on October 1, 2025 do not meet the requirements of a verified complaint pursuant to N.J.S.A 483. This exhibit details the office's determination. They invite the party to refile a verified complaint and order to show cause, provided it is accompanied by a new $175 fee. At the bottom of the page, where a signature belongs, the letter is signed only by, quote, the Office of the Union County Surrogate. No individual put their name to this determination. An anonymous rejection creates a legal hurdle without providing a specific official to hold accountable for the logic behind it. Segment 3. The letter's two halves. Read the letter's own description of the papers, a notice of motion. Now read the standard it applied, the requirements of a verified complaint. A motion is not a complaint. Measuring one instrument against the strict requirements of the other is a conscious act of administrative discretion. To understand the impact of that choice, we have to look at what was actually inside the rejected package. As this exhibit shows, Relief Paragraph 5 explicitly asked the court, quote, to assess the conflict of interest arising from the deputy clerk's dual role as a litigant in this matter. The pleading asserting a conflict within the office is the exact pleading the office determined did not qualify for filing. Segment 4. The law of the filing window. New Jersey Court Rule 1.5.6c is unambiguous. It states, quote, the clerk shall file all papers presented for filing. Filing is a ministerial duty. A clerk does not have the authority to evaluate a document's legal merit before stamping it. Any objections to a paper belong to the opposing party in the lawsuit, not the clerk at the window. The Appellate Division addressed this directly in White v. Katz, ruling that a clerk who returned a complaint he deemed non-conforming acted, quote, entirely erroneously. This standard goes back a century. In Mencken v. Meltz, the court held that a paper is, quote, filed in theory and contemplation of law when lodged with the proper officer. Under the law, the surrogate's office possessed no discretionary power to withhold the file stamp. The state rulebook outlines a specific list of reasons to use a received but not filed stamp, such as a missing case information statement or a lacking signature. Not in pleading form is not on that list. And because the sworn affidavit clearly records that the fee was tendered at the counter, the final administrative excuse for rejection is removed. As a result, the document remains completely trapped, physically held by the administrative office, but legally invisible to the court itself. The motion package was received. It was never filed. How does a justice system function when the referee in a dispute is also an active party in the litigation? We can see how this plays out by examining a dispute over record custody within docket S8455 in the Union County Surrogate's Office. Segment 1. This slide shows the text of the foundational law passed by the legislature in 1999 to handle institutional conflicts, N.J.S.A 2B14-4. On this typeset plate, Paragraph A sets an absolute prohibition. Neither the surrogate nor any employee may perform duties regarding a matter if they hold an interest in it. Paragraph B provides the mandatory remedy. Any disqualified matter must be transferred to the assignment judge. Notice what is deliberately missing from this text. There is no intent element and no good faith exception. State of mind is irrelevant, only the existence of the interest matters. This statute acts as an automatic safety valve. It is designed to instantly strip jurisdiction from a conflicted office to guarantee a neutral legal process. In the fall of 2025, a subpoena directly tested the surrogate's custody of its own records. Segment 2. This court order from October 2, 2025, provides documentary proof that the surrogate's office did not act as a neutral clerk. Reading the text of the exhibit, the document details exactly who brought the matter to the court. The motion was opened by Bruce Bergen, identified explicitly as counsel for the Union County Surrogate's Office. The outcome is clear. The office's motion to quash the subpoena was unopposed and granted. Look at the signature block. It was signed by a Superior Court judge, designated N.J.S.A, bypassing the statute's mandate to refer the matter to the assignment judge. Instead of referring a conflicted matter away as legally required, the office actively litigated access to its own records as a direct party. That same one-page order contains a secondary, explicit command. Segment 3. The highlighted text on this card shows the court's exact service directive, quoting, "A copy of this order shall be served upon all parties within 5 days." As noted in this exhibit layout, no proof of that required service exists in the estate's file. The order only surfaced in the record 3 months later, in January 2026, as a mere attachment to a later state filing. The record shows this gap, but does not provide a motive for it. For 3 months, the adverse party was completely blind to the fact that their subpoena had been quashed by the very office they were investigating. These procedural anomalies prompted a formal, direct attempt to trigger the statutory safety valve. Segment 4. This card displays an affidavit of service for a filing prepared on October 30, 2025, an emergent application for supervisory intervention, properly addressed to the assignment judge. The application relied on precise legal mechanics. It invoked Rule 133-4 and quoted the 1999 disqualification statute verbatim, demanding the transfer required by law. This exhibit details the irrefutable proof of delivery. The application was sworn served on November 3, 2025, via the trial court administrator, and properly served on the adverse party. Based on a status inquiry filed on January 2, 2026, the system's response was total silence. When the exact statutory mechanism designed to prevent conflicts of interest was manually and formally triggered, the justice system simply did not answer. The statute names the referee. The record shows the referee was a party. We are pausing the timeline for an interlude. This is a direct examination of the exact unaltered record of docket S8455. We need to analyze exactly what the family's refused legal papers asked for, and place those requests side by side with the motions filed by the state actors who moved against case access. Segment 1 starts with the motion tendered to the court on October 1, 2025. The caption of this pro se filing lists explicit requests: notice of motion to appoint co-administrator, or in the alternative, for leave to intervene, for declaratory and injunctive relief. Panning down, the motion is addressed to Kimo Abasi, attorney for the public guardian. The summary is straightforward. The family was asking for a seat at the table. These represent the standard legal mechanisms for participation, establishing the baseline for how the family attempted to engage with the court. Segment 2 looks closely at the 10 specific relief paragraphs contained inside that motion package. Focus on paragraph 2. The movant formally asks for, quote, leave to intervene in this matter as a party pursuant to Rule 4.3-1. Under New Jersey rules, intervention is requested by motion. There is no requirement to file a verified complaint to ask for this status. The remaining paragraphs request a plenary hearing, examination of the public guardian under oath, and verification that the court record is complete. When the clerk's office rejected the package, their October 2nd letter measured the filing against the standards of a verified complaint, a standard the request was not required to meet. By applying an inapplicable legal requirement, the office effectively blocked a rule-compliant request for transparency. Segment 3 tracks the family's escalation. After the first motion was marked Received Not Filed, they moved the issue up the chain of command. On October 30, they submitted an emergent application for supervisory intervention. This invoked Rule 133-4, appealing directly to the assignment judge's authority. Inside, the brief cites the disqualification statute, 2B:14-4, and the filing duty law, stating the clerk shall file all papers presented. The family attached Exhibit L as proof, the staff's own email admitting papers were marked received because they were not in pleading form. The record shows this application was properly served on opposing counsel and served to the assignment judge's office. Despite the presentation of written evidence regarding the clerk's rule violations, the family received no acknowledgement. The document generated no docket entry and no ruling. This silence at the supervisory level left the filing refusal in place. Without a ruling or a docket entry, the family remained legally excluded from the very case they sought to enter. Segment 4 looks at the other side of the V, the movements against access. In March 2025, County Counsel and the Public Guardian both filed motions to quash. The court granted those motions by June. In October 2025, the surrogate filed a motion, which was granted unopposed. In January 2026, the Administrative Office of the Courts filed a motion through the Attorney General. It was also granted. While the family's motion sought entry to the case and the file, the government offices moved to limit that access, and the court granted each of their requests. The final tally for the family's September and October filings stands alone. One motion was never docketed, and the escalation was never ruled on. This record documents a dual track. The system efficiently processes requests from state entities to limit participation, while ignoring procedural mechanisms used by citizens to seek inclusion. The cumulative effect of returning documents unfiled is a denial of basic transparency. These ignored documents asked for 3 things: a referee, the file, and a seat at the table. Act 6 of the Union County Surrogate's Office series, focusing on the 2 titles. Segment 1. Rule 115-1, paragraph C, states that an attorney who is a surrogate or deputy surrogate, or who is in the employ of any such official, shall not practice law in any estate or trust matter, in or out of court. Verified against court rules, the prohibition is tied to employment by a surrogate, regardless of a letterhead using staff attorney or counsel. The rule applies to estate or trust matters. This raises a scope question. Does a guardianship qualify? While the film flags that broader question, the specific correspondence documented here concerns the estate of a deceased ward, a matter that is captioned as an estate case. Within these parameters, a surrogate's office attorney is restricted from practicing law in these matters. This is the first boundary of the record. Segment 2. Rule 115-2 approaches the same issue from the opposite side. It states that an attorney serving as a clerk or deputy clerk of any hort shall not practice in any court. The rule provides for only one specific exception. That carve-out names exactly 2 statutory offices, the surrogate and the deputy surrogate. The exception does not include counsel. This creates a collision. If an attorney performs deputy clerk acts while practicing as counsel, they occupy a position where authority and disqualification are triggered by the same sentences. Segment 3. The Code of Conduct for Judiciary Employees governs this entire architecture. It applies to all non-judge employees performing judicial branch functions and takes precedence whenever its restrictions are more demanding than other professional codes. This code establishes clear limits on the scope of employee authority. Under Canon 1G, court employees are forbidden from refusing to enforce a properly issued rule and are strictly prohibited from exceeding their issued authority. Rule 117(1-G reinforces this by classifying every person employed by or regularly assigned to a surrogate's office as a person serving the judicial branch. These employees are not simply county staff. They are subject to the judiciary's own ethics rules, which lock these restrictions into place from above. Segment 4. The county's public directory lists Lisa Taylor Brophy as a staff attorney. However, the emails in this record, sent to private counsel, the state, and unrepresented citizens, are signed Counsel Union County Surrogate. Rule of Professional Conduct 1.13d requires a government lawyer to clarify their client's identity when a misunderstanding of their role is foreseeable. For a pro se party dealing with the office that holds the case file, the signature title serves as that explanation. This analysis remains focused on the logic of the law and the record. It does not accuse any individual of a crime. It identifies a single missing piece of evidence, the instrument, if one exists, that designates this employee as a deputy clerk of the Superior Court. If that instrument exists, the clerk bar of Rule 115.2 attaches immediately. If it does not, then deputy clerk acts were performed without the required legal authority. 2 rules, 1 office, and no third position.
This is an unnumbered interlude titled The Record from the Well. It is a study of authority within the Union County Surrogate's office. These quotes come from audio recordings of 2 hearings, processed through automated speech recognition. To ensure accuracy, they were cross-checked across 2 independent passes. These are not certified transcripts. Rule 2-5-3 certification is the only path for official court use. While they lack an official stamp, these recordings capture the raw, verifiable reality of a courtroom procedure in motion. A standard courtroom sorts voices into specific roles. Witnesses swear an oath and face cross-examination. Counsel argue. Their arguments are not evidence. Clerks track the schedule. They do not testify. But in 2 hearings under docket S-8455, a 4th action took place. The factual record regarding filings, deadlines, and notice was supplied directly from the well of the court by the surrogate's counsel, speaking entirely unsworn. This is a systemic short circuit. An unsworn administrative voice bypassed standard evidentiary safeguards to become the factual foundation for the case. Segment 2 looks at July 11, 2025. This was the hearing that relieved the administratrix's lawyer. When the issue of missing opposition papers arose, the bench did not ask the adversarial parties. It asked the administrative office, quote, "We haven't received any papers, have we, Miss Brophy?" The unsworn reply provided the facts. "No, we received an email asking when their opposition would be due. Our office did email back and tell them it was due July 3rd, and we never received anything. And I was copied on the email that Miss Métis' law firm sent to the client yesterday." Count the facts established in that single answer. First, the court had 0 receipt of the required papers. Second, the July 3rd deadline was set not by a formal order, but by the office's own email. Third, the adversary's notification to its client was confirmed because the surrogate's counsel was personally copied on the message. The hearing proceeded on that record. Counsel was officially relieved that day, a decision resting entirely on those unsworn facts. Segment 3 moves to March 5, 2026. A new judge is holding their first status conference in the matter. The operative order needed to be identified, and its distribution verified. The court turned to the office to confirm this, asking, "Miss Brophy made you copies of the most recent order?" The answer, "It was emailed to us." The office's outbound email functioned as the official record of notice. This fits a historical pattern in the docket. The February 5, 2024 order explicitly routed its own service through the deputy clerk of this court. A later order on June 24, 2025, deemed service complete merely upon upload. The architecture of notice shifted. Proof of service was no longer driven by sworn adversarial affidavits, but by the unsworn actions of the court's own administrative apparatus. Segment 4 looks at the dual reality. The innocent reading, clerks confirm receipt and circulate orders daily. Nothing suggests the administrative answers were inaccurate. But the architectural observation remains. Facts on which rulings turned entered the record without the safeguard of an oath or cross-examination. Furthermore, these unsworn facts came from the counsel of an office whose employees are explicitly barred by the rules from practicing in this specific matter.
The administrative office serves as the memory of the case. At these two hearings, that memory was inadvertently substituted for examined evidence. Nothing suggests her answers were wrong. The question is why they were evidence. This is Act 7 of 8 of Received, Not Filed, the Union County Surrogate's Office and the Questions Reserved for Judges, the Innocent Twins. Every act in this record has an innocent reading. To test the integrity of this analysis, we have to state those counter readings in their strongest possible form and see what remains. Segment 1. Twin 1. The Helpful Clerk. Clerks answer procedural questions all day. The Employee Code's own commentary permits answering questions regarding court procedures. This is a reality of daily practice. Litigants call, and clerks guide them. Answering these inquiries is a standard, expected duty. The Judiciary Employee Code's own commentary explicitly permits staff to answer questions regarding court procedures. Some of the record belongs to this twin. When the office advised that a notice of motion was the correct vehicle for a request, that action sits safely inside this harbor. We concede that point without reservation. But notice where the safe harbor draws its line. Telling a party which form to use is court procedure. Determining whether a named fiduciary owes a court-ordered accounting is not. Deciding whether an existing judgment bars a property sale is not. Instructing a party on which of two blank bond options should be elected is not. And ruling on whether a tendered pleading meets the legal requirements of a rule is not. The safe harbor protects the first kind of answer. Every contested act in this record is the second kind. Segment 2. Twin 2. The Small Office. The most natural reading of all of it. A lean county office where the lawyer is the most capable person, acting as the surrogate's hand. This is a highly plausible, common-sense explanation for what we see. A surrogate delegates tasks to their most experienced staff member. We concede this description entirely. Nothing in this analysis requires the office to be operating otherwise. The answer to the small office twin is not a dispute about their daily workflow. It is that the rules of court exist specifically to regulate exactly this kind of arrangement. Rule 115-2 contains a specific carve-out, and the Employee Code maintains a strict authority canon. These are backed by the statute's closed lists of explicit powers. All of these rules exist precisely because offices delegate. They draw the rigid lines that delegation may not legally cross, no matter how natural or efficient it seems. A structural defect does not require a wrongdoer. That is exactly what makes it structural. Segment 3. Twin 3. Everything lawful stays lawful. Scheduling, expressly authorized, R483-1. Here is the full list of lawful conceded authorities present in the record. Scheduling hearings and fixing return dates is explicitly granted by Rule 483-1. The surrogate's court filing stamp on Surrogate is prescribed by Rule 1.5-6b5. Employing a lawyer in the office is authorized by Statute 2B14-13. And using a county email address for a county employee is entirely proper. We claim none of these administrative actions as violations. Any reading of this record that treats these routine administrative tasks as suspicious is overreaching. The structural failure lies elsewhere. Segment 4. And what the film does not claim: no crime by anyone, no forged order. We maintain strict boundaries on these claims. There is no accusation of criminality, nor is there any question of a forged order. No intent, coordination, or knowledge beyond the documents shown. We assume nothing beyond the exact text of the writings on the screen. We also do not claim that any staff answer caused the financial losses in the underlying estate. Causation is a separate legal question requiring a separate record. Finally, we do not claim that the office's statutory officers are idle. The record demonstrates a special deputy surrogate successfully performing lawful relay functions. This proves the office is fully capable of working exactly as designed. So we are left with what remains after every single concession is made. The claims are narrow. First, a purely documentary sequence of dated writings. Second, an architecture of rules that commits each of those contested questions exclusively to a judge. And finally, a strict question of authority that no document produced so far answers. The innocent readings are real. The architecture is what answers them.
This is Act 8 of Received, Not Filed, What the Rules Describe Instead.
The preceding acts showed exactly what happened. This final act shifts away from past actions, focusing entirely on what the rules actually dictate. The New Jersey Rules of Court establish a system of required procedures for every administrative anomaly. This brings us to the central question of this record. What happens when the documented actions of a clerk deviate from the explicit written text of those rules? These rules are designed so that specific inputs require specific judicial outputs, effectively removing administrative discretion from the process. Segment 1. We must run each act back down its lawful road. The blank bond paragraph is flagged to the judge. The accounting duty question is routed to the judge. And sealing records requires a formal motion, a movement's burden, and a court order. A blank goes to the judge. A duty question goes to the judge. A seal requires a court order. Rule 138.11 expressly provides that a record may not be filed under seal absent a prior court order. None of these procedural roads are exotic, and none are slow. The structural design ensures that every administrative anomaly is exactly one referral away from the judge's courtroom, forbidding unilateral action by the clerk. Segment 2. The rules governing the filing window itself follow this same design. If the office believes a pleading is non-conforming, it must be filed regardless of the clerk's opinion. The rule is explicit. The clerk shall file all papers presented for filing. Testing that document falls strictly to the adversary in front of the judge, not the clerk at the window. That allocation is the holding of White v. Katz. Objections to a non-conforming paper belong to the adversary. The same strict routing applies to an office with an interest in a matter. The file must immediately leave its hands. The command of Statute 2B14-4B states, "The matter shall be referred to the assignment judge of the county for appropriate disposition." The repeated use of the imperative word shall acts as a mechanical valve. It systematically strips the filing office of any discretionary gatekeeping authority. Segment 3. Step back and the broader architectural design of the courts becomes visible. Let's examine the operational rule inside the surrogate's own court, where the surrogate acts as the judge. Rule 482 establishes the primary fail-safe trigger. Any matter of doubt or difficulty routes the issue entirely out to the Superior Court. This document shows the corresponding rule in the Superior Court, revealing a mirrored logic. Rule 483-1 governs the Superior Court, where the office acts merely as a deputy clerk. This rule withdraws the clerk's authority using the exact same doubt or difficulty trigger. Two courts and two distinct rules follow a single principle. This trigger is self-operating. It does not wait for a party to file an objection to activate. It also does not depend on the clerk noticing the difficulty. Regardless of the building or the hat worn, the legal architecture strictly forbids the clerk's office from resolving any doubtful or difficult question on its own. Segment 4. What remains open, stated plainly, are the items that production would resolve. First is the designating instrument for deputy clerk authority. This is a single document that either exists or it does not, and each answer carries profound legal consequences in either direction. Second is the office's election regarding legal privilege over its counsel's correspondence. This is a strict binary choice. Claiming privilege defines the communications as client work, while declining it makes them records of the court's file. Third is the unread balance of the correspondence. As this film states, it has quoted only the messages reviewed. Finally, there is the judicial void. The questions posed by this record remain completely unanswered by any court. This presentation is an analysis of logic and law. It accuses no one of a crime. It simply isolates the administrative anomalies that now demand documentary proof. The film ends exactly where the administrative record does. What happened is thoroughly documented. Whether it was authorized is the ultimate open question. The questions are on the record. The answers require production. The burden has shifted entirely from systemic analysis to the mandatory production of authorizing evidence.